Hi, folks. You're at Tacitus Today, your pushback channel, and thank you for joining this audio live stream. In this essay, I'd like to talk broadly about the jury system, jury trials, trial by jury. And what's making the news recently is that in Britain, they're thinking of doing away with jury trials or jury trials in certain cases. Now, the jury trials issue, has been, if you like, on the among the issues that's being talked about in legal circles for quite a while. It didn't happen yesterday. The reason being is that jury trials take longer. You've got to impound the jury, and that's a lengthy process. Finding people get sick, or they try and pitch for exemptions, and then you've got to pay them for being there, and often there's negotiations in the back room, so the jury's sort of held in readiness. But then there's a deal, so the jury people go home and thank you for your public service, even though you've sat around for 2 or 3 days. All this sort of thing. So it's hugely disruptive to people's lives, and most people don't want to have anything to do with jury trials if they can avoid it. The unemployed and the those that they can, they don't care. They get paid for turning up. They get a free lunch and out of it, so that's fine for them. But for people who've got more active lives, maybe they've got you've got children, but you're someone's ill, or you can't afford the babysitters. What happens to the children, or the single mother, or there are all sorts of issues in people's lives that make the jury service a complication. And the dedication to sort of public service and to dedication to the obligations to the civis, if you will, they're nowhere near what they used to be years ago. It was an honor in some ways to be called for jury duty, and it was your right as a citizen to ensure that justice was done. That's a much more difficult concept for people to swallow these days. So the relative importance and the esteem with which citizens may have held jury trials or trials generally has changed. But I wonder, jury trials sort of going back, if you like, to the Magna Carta in 1215 in England. The king was behaving arbitrarily, particularly in regard to taxation and seizing people's lands and properties. This is the other aristocrats. So the aristocrats got together and thought, no, we've got to have codified laws here. So we've got some sort of stability in things to do with law, and we don't want the king just arbitrarily saying, I don't like you and I'm going to take all your lands. That there has to be law, that the king is subordinate to the law. Now, the king and the parliament will make the laws, sure, but then once the laws are codified, then we all have to live by those same laws. You can't just make things up as you're going along, was the argument Magna Carta. Now, Magna Carta, by the way, it was a lot of people think Magna Carta was done and then it was a done deal. England had jury trials, they had this, they had that. The king, in fact, tried to backslide out of the jury trials, out of the Magna Carta, and various aspects of it, and so the power between the aristocrats and the elected representatives to the assemblies, that waxed and went back and forth, where there was great concern over civil war, particularly over the dynastic succession. And England was often racked by various sort of civil wars. When I say civil wars, I'm talking wars of dynastic succession, I guess, really. For example, the invasion of England by the Normans wasn't considered to be a civil war, but really it was. The Normans came in and took over, but that was a war over dynastic succession, and there were numerous other wars. So things went back and forth with jury trials and so on, and it wasn't really until the later, say the mid 1600s, when the separation of powers, when it was accepted, look, we've got to have, the judiciary must be independent and it must be separate from the executive being the king and his immediate councillors. So nobody wanted dynastic wars of succession or civil wars. So the king had much greater power during those times while that fear existed. And if the king wanted to get rid of people that might have been potential troublemakers, there was frequently a tacit acceptance of arbitrary power and doing away with jury trials and replacing them with effectively courts of attainder, where the person is predetermined as the accused is predetermined as guilty. And so courts of attainder are frequently used by tyrannical monarchs. But where things were considered to be stable and there wasn't a risk of dynastic succession wars and so on, then the power swung back to the assemblies and the elected representatives. And as we saw in England in what was referred to as the Glorious Revolution, that is where a monarch who was believed to be acting arbitrarily and throwing his weight around was kicked out. Effectively, he's ordering the army to do this, or the police forces or the equivalent of them in the day. This is in 1688, and they didn't do it. So he had to, well, I'm out of here. I have no power left. I have no legitimacy left. And the power resided with the elected representatives. The army and the organs of the state did follow the orders of the parliament. And this was considered to be the time when the full separation of powers between the executive, the assembly, and the judiciary had been achieved, 1688. Not that it didn't have a bit of a pushing and shoving game over the full meaning, for example, of habeas corpus. Things like that still dragged on, but that was where things were made pretty clear as to the direction the legal or practice of law was heading. Now, even as if somebody was going to be denied their liberty or their life for that matter, then it was considered the jury trial was the only way to go. And this was to legitimize the decision. So the state could prosecute somebody for theft or say vandalism or things like that, which back in those days did often include, depending on the severity and the value of the damage or the theft, could include the death penalty. But these penalties were, even though they're codified under law, were considered harsh by the populace. And so in jury trials, if the accused was going to be, if the judge had it within their discretion to order the hanging or the death of somebody accused of whatever, the juries would not return a guilty verdict. They just wouldn't. So the judge then had much more limited discretionary powers, but they could say, okay, well, we're going to transport you to Australia or Botany Bay or Sydney Town, as it was then called. We're going to transport you to Australia and as part of your sentence, and you have to be there for 10 or 15 years, whatever the sentence might be. So jury trials didn't always deliver the verdict that the state wanted. The state wanted a death penalty, but they weren't going to get it. Juries just plain wouldn't do it. So that was a good example, an excellent example of the break on state power. The state accepted that. When I say accepted, if you look at the interlocking parts of a justice system, the the police, or there weren't really police, and the police didn't come along until the 1840s, I think. But there were various, city sort of prowlers that would go around, in the towns and the cities, effectively doing what a police force later would. But you had the police or the sheriffs, that sort of thing, and then the state prosecutors, then the independent judge, then the independent jury, and so on. So these are all interlocking parts as well as codified law. So the elected representatives of the people making the codified law. So there's a lot of interlocking parts here. So it was assumed that everyone would impartially do their jobs and discharge their jobs, that the jury would act impartially. But not in the case where the jury thought, no, this is not right. You shouldn't be taking that guy out back and shooting him. So we're not going to give you the guilty verdict here. But the state accepted that in the overall balancing act between the components of the justice process. And these interacting matrix of components in the justice process are very important to consider going forward in this essay. Now, when any of those components are changed, subverted, or corrupted, as they have been now, then the process doesn't work in a variety of ways. For example, if you have activist prosecutors or activist judges, or where the law is deliberately worded so loosely and vaguely that judges have huge arbitrary powers, or where the state will actively pursue one crime that they don't like for ideological reasons, but yet will let other crimes go equally for ideological reasons. Similarly, if ideology along the lines of, say, social power, the straight white male has to be held, Christian male has to be held to the various highest standard, whereas the third world peasant, is Islamic dude, isn't held to anywhere near that same standard. So he can go around beating up police and or raping and assaulting and robbing and destroying public property. And hey, so what? So social harmony, racial harmony is more important than punishing people for the crime. Whereas, if the white guy does exactly the same thing, or even something on a much lesser scale, then he's going to have the book thrown at him. So if someone says it's okay to be white, so they can get 2 years in prison. Whereas if the brown person goes and beats up a police officer, then they don't get any prison time. So these things were never foreseen. So when the the league, the parts of the jigsaw of that, which something occurred over many hundreds of years, it developed organically over time, where people were looking at the failures of the law, or where it wasn't working and wasn't sufficiently independent, and so on and so forth, and made gradually over time, bit by bit. So it was organic and happening piece by piece over hundreds of years. The legal system was developed, and I think it was probably as close as it's ever been to an independent, impartial legal system. Was it perfect? Well, no, and no one's saying that it was, but it's the closest to this ideal of perfection that I think we ever got. Then it started going rapidly backwards and downhill once ideology crept in. Why were black people being imprisoned at a higher rate than white people? Well, it's because they're committing more crimes. No, it's because of evil fascist Nazi racism and so on and so forth. Now, I remember at school, this is in history class, we were plied with, this is all reality and factual, about the Soviet show trials and the Communist Party show trials in China, the street courts and the like, where people were being arbitrarily arrested, and again, in courts of attainder, in effect, they couldn't have a defence against that. They had to just stand in front of the court and fess up. I've been a fascist and I've been bad. And similarly in the German courts, and the Germans were quite strict observers of the rule of law and due legal process, but or certainly relative to any other legal and judicial practice around, even the Nazis for that matter. But the Nazis wanted to make it easier to get at the Jews. Bear in mind, there was only 400,000 Jews in Germany out of a population of 80-odd million. So, and 200,000 of those Jews left to go to America and elsewhere. So that the amount of Jews left in Germany is very small. But the Nazi People's Court, the things they would do to the Jews were anyone could arbitrarily accuse them of anything. You're a rapist, or you're this, or you're that, or you said a slur word against Christians or Gentiles. And then the accusation was enough to have the Jews dragged into court. Then they used various devices to make it impossible for the Jews to defend themselves in a court of law. They would deny the Jews the right to call witnesses, for example. And so, I've got my witnesses outside, Your Honour, ready to come in, and I don't care. I'm not going to listen to any of your witnesses. And so the judges would act arbitrarily, as they did in the Soviet Union, as they did in China, in the communist regimes, as they did in Pol Pot's communist regime in Cambodia, the use of arbitrary law, so arbitrarily arresting, arbitrary due legal process, arbitrary application of law, and this is how the legal system, parts of it were subverted simply to get at people they didn't like for ideological reasons. Now, that was never perceived in the West. There wasn't an ideology in England, for example. There weren't those ideological issues to be argued over. The population was quite homogenous. They all spoke one language. They were, other than the class differences, and that was an issue. But other than that, there was a degree of homogeneity. And as the organs of the state had grown up and developed organically, there was, on a relative basis, a lot of confidence in them, a lot of belief that the verdicts and the conclusions were achieved or arrived at independently, notwithstanding that class difference, which was an issue. So this meant that when ideology came into the legal process, which it did, particularly from you could even see it before the 1990s, but definitely afterwards. There, once ideology came in, and to do with social power and why equity and why outcomes different, but also with the mass importation of people from the third world and other places around. A lot of illiterate peasants and all this sort of thing, and then the NGO activist class, the globalist controlled NGO, that was constantly trying to create social division. Well, why are the outcomes different? So this all created layers of, well, we have to correct this difference. So activist prosecutors, activist judges, activist police, and so on, that are operating along ideological lines, not along codified law lines. But the legal system was never designed to cope with that. It was designed, everyone will do their job impartially. Was it perfect? No, you get, corrupt, crazy folks would slip through the net. But now the entire net is corrupted and subverted. That activist judges, I was watching a case in England, just televised recently, where someone said that some low IQ black chick who's got some job was just a diversity hire, an affirmative action hire, which in my view she clearly was. But that's enough now for someone to be criminally convicted in court. Are you kidding me? But that's the level of ideology that now has infiltrated and subverted the legal system. And there's plenty of straight white males in Britain that are quite happy to go along with this ideological insanity, on the judicial side of things. No one ever thought that would be possible. So coming now to the issue of jury trials. Now, again, jury trials are an expensive way of going about things, and very time-consuming in Australia, for example, and in other jurisdictions. Instead of having a 12-person jury, they reduced the jury to 4 people. It's an expedient move just to reduce the cost and reduce the time. Judges have the power to overturn jury decisions. There's a case where someone was accused of racial abuse, and the jury came back very quickly with a not guilty verdict, and the judge said, don't like it, I'll overturn your verdict and convict the person as guilty anyway. So that even if you look at the amount of judges that overturn jury verdicts in Australia and elsewhere, they're far more likely to overturn a verdict that is not woke and politically correct, and make the politically correct ideological decision. Yeah, Billy Bob's guilty of racism. Yeah, throw the motherfucker in prison. He's a Nazi. So this is something that, but again, these things weren't foreseen when the legal system was put together. So, and again, it grew organically. So now we need a situation where we're protecting against, not per se the overreach of the state, definitely that in a tyrannical sense, given that all the representatives in Parliament and what are now globalist controlled, and subversion of the Western civis is the goal of the globalists. So infiltrating the judiciary and so on is a key component of that. You can see this too when Trump won the first term. The idea was that Hillary would get in as president, and she's just a globalist controlled stooge, and that they would mass appoint activist judges at all levels and all places, and they ended up not being able to do it, which drove them crazy with annoyance, because that was their plan, which they thought they had in the bag. But because Trump was there, constitutional judges were being appointed to the Supreme Court, for example, which was, to a large extent then and even today, or certainly today, is the only thing that's protected the United States from becoming a globalist shithole. If Trump hadn't appointed those judges, the US would be lost today, and even if Trump had been elected or re-elected, his powers would be substantially reduced, because there would be no court anywhere in the United States that wasn't globalist and ideologically controlled, or globalist controlled and ideologically subverted. Coming back to Britain and this idea of doing away with trials, well, if you look at the waiting list and the waiting list of cases to come to trial are growing by the day. They could appoint a lot more judges, build more courts, I suppose that's an option. But assuming that the current infrastructure is about going to remain the same, what we've got, or what they've got in Britain, is a huge list of people called Mohammed and Abdul and so on that don't speak a lick of English, or claim they don't. Now, this slows down the system, because they've got a jury, they've got to put juries in, they've got to find interpreters, and there's all sorts of arrangements have to be made. And the state is reluctant to actually prosecute these people. They don't really want to do it. Okay, Mohammed and Abdul have committed a lot of crimes. Okay, fine. But if they stringently apply the law to Abdul and Mohammed, then a lot of these people are going to be in prison. They don't want to do that. The state doesn't want to do that. White person doing a mean tweet or something on social media, that's okay, send them to prison, but they don't want to have lots of Abduls and Mohammeds going to prison. So they've got an ideological issue as well as a logistical issue, that the backlog of cases. Now, if there's a jury which is has some sort of wildcard effect, they may have enough people on that jury to secure convictions, to come back as guilty. In a lot of cases, the crimes that the Abduls and Mohammeds commit are not what you'd call sort of well thought out. They're captured on CCTV. They're typically dead to rights, and there's no ambiguity or ideology to be applied here in assessing the criminality. That they've committed the crime. So they're looking at, in many cases, where the jury will convict. So in order to have some sort of semblance, at least, of legitimacy of the legal system, they can't have juries convicting and judges letting people go just across the board all the time. So what if they do away with juries and judges just hear the case? Now, the arguments, well, the law is so complex. Only judges. No, that's bullshit. That's the cover story. If it's a dead to rights on CCTV and so on, these people are guilty. Abdul's guilty, and he's going to go to prison. But they don't want that. That's not ideologically and logistically, and according to the globalist talking points, it's not what they want and not the outcome that they want. So if they can get rid of juries for say cases where, and I think I'm going, this might be it. Say if the prospect of more than 2 years or so of detention in prison is the range of penalties for the crime that allegedly is being committed. If it's more than 2 years, maybe more than 3 years, then juries may still or can still apply. But if it's a lesser sin where it's likely to be less than 2 or 3 years, 6 months or something, that type of stuff, then do away with the jury, even though it may be a term of detention. Do away with the jury and then have a judge hearing. With that basis, they've now got thousands upon thousands of cases of Abduls and Mohammeds clogging up the system, where they much more latitude to make plea deals. The judge can go, oh well, look, Mohammed, that was naughty. You shouldn't have done that. 18 months suspended sentence and 500 hours of community service. He won't even do the community service. There'll be some NGO that he'll be supposedly going to do the community service with, it'll just sign off his form. He won't need to do squat. So in that way, they can avoid the racial aspect of things, having too many Abduls and Muhammads in prison, and also avoid overloading the prisons, of course, and also process many more cases far more quickly. If you've ever been in a court of petty sessions, as I have been in a few times, watching things there, you've got a magistrate, junior magistrate judge in there, and they're hearing sort of that they can hear, in a few hours, they can hear 20, 30 cases. So it's usually quick processing stuff. Okay, and the cases, by the way, are small. Some that I remember, there was a son had borrowed, $500 from his mum, and he hadn't paid it back. I hadn't paid it back on time. I wasn't paying it back quickly enough, so she decides to take him to court. and he's not a bright guy, nor is she. And he says, "Well, I haven't got a job. How am I going to pay her back?" And she said, "I don't care. He should pay me back anyway." And you can see the judge looking at her going, "Holy crap, why am I?" The state isn't necessarily involved in any of these cases. It's private individuals trying to sue each other. Another one, a woman had a prized rose bush. She won some prize in some rose bush competition or something. And the roses were overhanging the fence of the next door neighbour. The next door neighbour apparently asked her, "Well, can you trim your rose bushes?" She said, No, it's a prize-winning thing. So the neighbour cut the rose bush, or the overhanging part of the rose bush. And so they decided that the woman, "I'm going to sue you for that." And how these would ever get to court, or why someone would think about that. So a lot of it is very sort of petty, snotty type cases. There were other cases. One other case that was far more serious, and the judge was to decide whether or not it should go on to a higher court, where the police had arrested some kid for, I think, having some marijuana. It turned into a punch-up, and the kid and the police officers were swinging at each other, and that type of thing. And that was a serious matter. There's another one where, and it's interesting watching a judge here. The judge in the case of the kid was this is the kid swinging at the police, and I think it is a serious matter, assaulting a police officer. So the judge said, "Well, I don't care about points A and B, and where the kid said fuck off, or something. They don't care about that, but I do care about assaulting an officer of the law. And as far as I'm concerned, this may involve you going to prison." And the kid, they didn't really sink into the kid, and his attitude wasn't helping. But the father nearly had a heart attack there in the court, and he was whispering to the lawyer in a voice you could, or trying to whisper in a voice you could hear, so, appeal it if they throw my son in prison, appeal it, any amount of money you want. And the father did look like he had a buck or two, but those are cases as well. But these aren't heard by juries. They're just heard by a magistrate on their own. So this would be how it would play out, I think. As soon as juries are got rid of, they would have a quick processing. Okay, what's Abdul accused of? Robbing, assaulting, and raping. Okay, look, Abdul, given that you've only arrived in a third world country from a different culture and this sort of thing, I'm not going to put you in prison this time. 18 months suspended sentence, community service. Bang, thanks, Abdul. Get the fuck out of my court. I got another case. I think it would go like that. And so that would be a huge change, but it would still be a mass subversion of the legal process. This is only occurring because there were no masses of Abduls and Muhammads years ago. There were no other cultures to think about or cater for. There were class differences, but there are no other cultures. There were no language translation issues or any of these sorts of things. So these sort of things are being imposed on a legal system was never designed for that. And so on that basis, doing away with jury trials is, I think, a reflection of the systematic and mass subversion of all our civic situations and systems and processes and institutions in the West. And that's what we're looking at. And that's what needs to be addressed, not whether we do or don't have jury trials. You've been a Tassus today, your Pushback channel. Thank you for listening.